Hi. When we started this course, we talked about how important the institution of employment was. And we talked about how employment affected so much of our daily lives. It affects the health care that we receive. It affects the retirement that we have. It is going to affect not only our friends and acquaintances, but also perhaps our spouses and our boyfriends and our girlfriends. And maybe even it's going to determine your identity, what you think of yourself. And so think of all those things, all those aspects of your life that employment is going to govern. And then imagine a situation in which all of those things are going to be decided about employment when in fact you are going to have a different employment based on factors that were present at birth, things that you cannot change. This is not a situation of getting more education or getting more experience. These are factors that are present, that are immutable for the most part, unchangeable, and that could affect your entire life. And so in this section of the course, we're going to talk about discrimination and the aspects of discrimination, and what we're focusing on, of course, is illegal discrimination. Discrimination that is against the law. And we start out that discussion by looking at race and color discrimination. Now, we know that the drafters of Title VII, part of the Civil Rights Act of 1964, were most concerned with racial discrimination. The Title VII arose out of the civil rights movement of the 60s, which was focused on racial discrimination. And at the time when we thought of racial discrimination, that meant black and white discrimination. And so that was the focus of Title VII. Now, the other protected classes that we've alluded to, that we've talked about, things like sex and religion and national origin, those were not as important as race. And so we have always looked upon race as receiving the highest protection, and acts of illegal discrimination receive the most scrutiny. Now, part of the problem with examining the situation of race is a definitional issue, that there is no adequate definition of what race means. It's not included in the statute. Ordinarily, when you want to know what a statute means or who it applies to, you look into the statute for a definition. But there's no definition of race. And I think that was in part because at the time, when you talked about race, you thought about it in terms of black and white. And so there wasn't the need for a definition, because everyone knows. You can just look and see. But of course, over the years, since Title VII, we've seen tremendous changes in the concept of race, and those underlying changes have affected how the law is applied. Now, part of the problem with definition is that the concept of race is a really relatively recent invention. And it was created by Western Europeans in the 17th and 18th century. And it was done so for the worst possible reason, which was as a justification for slavery. That if the European powers were going to colonize the rest of the world, especially the Americas, they realized that they could only do that through the institution of slavery. And they knew that slavery was wrong. So there's no question that they knew slavery was a bad thing. But they needed a way to justify it. So how do we justify that? Well, at the time, this is taking up sort of post-Enlightenment Europe, in which there's been this movement toward scientific rationality and categorization. And the belief was, well, let's put people into categories And therefore, we can determine how the world is going to interact with those people based on the category that they belong to. And so, in order to justify slavery, they had to create a reason for slavery. And the reason for that slavery was race. That race was created in order to justify the pre-existing institution of slavery. Now, this is not to say that that there had not been slaves before. We've seen slaves throughout history in ancient Rome and Greece and Egypt. We know that there have been slaves, but the kind of slavery that we saw in the New World, the Western Hemisphere, for the most part, as instituted in the 18th and 19th century, it was a different form of slavery. It was based on hereditary factors, things that were present at birth. And if you were a slave, then that meant your child would be a slave, and their children would be a slave, and so on and so forth. And so this hereditary notion of slavery had not really existed prior to this time. So they needed a way to justify that belief. And that justification came out of the invention of race, that we are going to use race to justify this horrible institution of slavery. So rather than maybe what you think, which is that race created slavery, that people were enslaved on the basis of what race they were, in fact, it's just the opposite, that slavery created race. It's a tough issue, and for those of us in the U.S., we have to deal with the fact that slavery existed as an institution for centuries, and therefore the idea of race became institutionalized in our system. And therefore, despite years of effort, the problem of racial discrimination remains. We'll see in this class that the first Civil Rights Act was enacted in 1866. And so 100 years later, we had the second Civil Rights Act, which was meant to address the problems that the first act didn't solve. And now here we are 50, 60 years after the Civil Rights Act in 1964 and still dealing with this issue. So in this lecture, we're going to look at Title VII and its treatment of racial discrimination. Now, Title VII was aimed at racial discrimination. That was the primary focus of Title VII, was eliminating the problems caused by racial discrimination. And it does so by making racial discrimination illegal. The statute says, "It shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual, basically any employment decision, because of that individual's race or color." So these are our first two protected categories under Title VII, race and color. And we'll talk about the legal meaning of color in a bit, but let's focus right now on race. Now, of course, history, as we discussed, and its effects account for much of today's racial discrimination. That slavery was this part of an American life, an integral part of American life, for over 200 years, and has remained an issue for another 150 years past its abolition. So the problems of slavery are ongoing, and in large part because during the slave holding era, a number of legal structures institutionalized race, meaning we created legal categories based on this unscientific notion of race. And the thing that makes racial discrimination different than the other types is that we have this large historical effect. And so it's not enough to say that that yes, we know that race doesn't really exist, that it's a category invented by Europeans in order to justify slavery. But yet, for generations now, we've been taught that it does exist and it does have meaning. And therefore, even if it's not real, we have to treat it as real. Now, as I mentioned, the first Civil Rights Act in the United States was actually passed in 1866. There were actually several acts, and together I grouped them under this 1866 Act. And these are normally called the Reconstruction era Civil Rights Acts. The Civil War had ended in 1865, and the Congress decided that they would restructure the United States. And they would do so in several ways. And one of the first steps they took was to enact the 1866 Civil Rights Act. And that will include 3 sections that we'll discuss in here that are related to employment and remain relevant today. That even today, we are still filing lawsuits and adjudicating this issue about racial discrimination in employment based not just on the 1964 Title VII, but on the 1866 Civil Rights Act. So these Reconstruction era acts remain relevant today. And these actions are going to be brought by the employee suing the employer in court. There's no need for the administrative procedure involving the EEOC with bringing an action under the 1866 Civil Rights Act. Now, there are these 3 sections, and I want you to know the sections, and the section numbers sound like years, but don't get confused, they're not years. The first section is called 42 U.S.C. Section 1981, and this is really the most important section of the Civil Rights Act. Section 1981 guarantees equal rights under the law to make and enforce contracts. Remember that notion of freedom of contract and how we are going to, freedom of contract was supposed to solve the problems of the Industrial Revolution. Freedom of contract was going to solve workplace safety issues, and it was going to solve the need to pay people a decent wage. Freedom of contract was the concept, the ideology that was so prevalent in this latter part of the 19th century. And so what the congressional members intended at that time was to guarantee the right to make a contract without regard to race. And the thought that that's going to solve all problems. That's going to solve employment issues, because now you can't make an employment contract and take race into consideration. It's going to solve social issues, meaning a contract to buy a house can't be dependent on race. The contract that's executed in terms of buying dinner means that you can't exclude people from your restaurant. So Section 1981 carried with it this concept that we're going to solve the problems of racial discrimination by guaranteeing the right to make and enforce contracts. Now, the Civil Rights Act of 1991, don't worry about this. It overturned a decision that said that it was only in the making of contract, not the enforcement of contracts. That in fact, enforcing of contracts is protected. Now, Section 1983 protects against discrimination involving state action. 1983 protects citizens from the deprivation of their constitutional rights under color of state law. So when you look at 1981 is aimed at private employers. Private employers are forbidden from using race in the making of their contracts. 1983 instead is aimed at the government. public employers, even when those public employers are acting not in the capacity of a government, but acting as private employers. So under color of state law means that we are going to protect people based on this against governmental discrimination. So Section 1983 applies to public employers and to any employer associated with a governmental entity. Now, the best case on this is a case called Jett versus Dallas Independent School District. And make sure you know this for your test, because this fact pattern will probably appear somewhere. Now, Jett versus Dallas Independent School District involved a high school football coach who taught at South Oak Cliff High School in Dallas, Texas. And the coach was white. And the coach had been a coach at South Oak Cliff for decades, had been there for a long time. Now, in that time period, Oak Cliff had changed its makeup. It went from a predominantly white suburb of Dallas to a predominantly black inner portion of Dallas. And so the student body was very different in the late 80s than it was in the 1960s when the coach went to work there. Now, a new principal was hired, and the principal was dismayed at the football team's lack of success. And the principal believed that the problem was that the old white coach could not relate to the young black men on the team, and therefore needed to be replaced. And so the principal, in essence, fired the coach and actually reassigned him to a different area not involving coaching. And the coach still wanted to coach. And so the coach brought a claim under Section 1983 that the decision to remove him from his job as football coach was based only on his skin color, and therefore was a violation of Section 1983. So what you'll look for in your test is anytime there's a public employer involved, a public employer may be subject not only to a Title VII claim and not just to a 1981 claim, but also a 1983 claim. The third statute, Section 1985, is aimed at conspiracies. Section 1985 prohibits conspiracies to interfere with civil rights. This was originally entitled the Ku Klux Klan Act, and it was meant to prevent those sort of conspiracies who were aimed at interfering with the civil rights of black Americans. Well, how does this apply to employment? Well, what you will see is that if two or more companies are engaging in actions that are designed to not hire or to take adverse employment decisions in regard to people, then that could rise to the level of a violation of Section 1985. Now, just as with 1981 and 1983, 1985 applies equally to black and white across the board. So, in the same way that Title VII is agnostic and applies to both minorities and majorities, to men and to women, so 1985 applies to all races and not just a minority race. So this 1985 addresses conspiracies that are designed to deprive the civil rights of others. The case on this is, there's not actually an employment case that's good to discuss. There is the case of Mississippi burning, and if you look that up on Google, you'll see that during the 60s there were a number of actions taken by private individuals in terms of depriving black Americans of their civil rights, and the response was to file a lawsuit based on this Section 1985.